Pravin Gordhan filed court papers today slamming a report by Public Protector Busisiwe Mkhwebane. Gordhan wants the High Court to set aside the report, declaring it unconstitutional, unlawful, irrational and invalid. The report found Gordhan guilty of improper conduct for approving early retirement with full pension benefits for former Deputy SARS Commissioner Ivan Pillay. Gordhan's legal representative Tebucho Malachi joins me now. Good evening, sir, and thank you very much for your time. Now, you want this report, which was released on Friday, set aside. What are the reasons that you are giving the court?
A number of reasons. We firstly contend that she shouldn't have entertained the complaint to begin with. It's an old complaint, 2010. Has been investigated by other authorities, including the National Prosecution Authority, which applies the highest standard in terms of assessing a set of facts and laws and whether they've been contravened or not. And that's our first port of call in terms of our complaint. Secondly, we say we concern that she hasn't given due consideration to our submissions given to her on Wednesday, and she releases the report on Friday. So we've got process complaints, if I can call them that. And then on more substantive basis, we contend that her findings are premised on factually incorrect premise. Firstly, she says Mr. Pillay didn't retire. He did, in fact, retire. And secondly, she says that Minister didn't have the power to approve a retirement at that age of 56 with full benefits. We say the law allows any minister, not only the Minister of Finance, any minister, to allow an employee to retire between 55 and 60 with full benefits.
Now, let's go to the former, the issues you raised initially. Why are you saying that she didn't give any due consideration to your submissions?
Think of it this way. It's a complex matter from a legal perspective. 3 submissions are made by different parties. Mr. Pravin Gordhan makes a submission, Mr. Pillay does, Mr. Mahashula does. And in a matter of 2 days, all of those are processed, considered, and a final decision issued. We think not, because in the ordinary course of events, you would expect that, given the complexity of the matter. So you're saying she couldn't have done that in the 2 days she had before releasing her report? That's exactly the point.
And on the other issue you are raising, that she should not even have considered the complaint, what are you basing your opposition on?
Remember that this complaint is not new. It's events that took place in 2010, so we start there. Her own legislation, Section 6, subsection 9, says she may only entertain complaints older than 2 years if there are special circumstances. She can exercise her discretion to entertain that kind of a complaint that is stale. And we say, having regard to all the circumstances, and consider this, in 2016, there's a very dramatic events in South Africa relating to Minister Pravin Gordhan relating to his prosecution. Now, the then prosecuting authority has regards to our submissions, and remember those would have been based on the same set of facts, they haven't changed, and those that have been based on the same set of laws, they haven't changed, and he applies a higher standard. Did you commit a crime or not? And he comes to the conclusion, no, he hasn't. Retired Judge Nugent looks at the same matter during the commission and arrives at the same conclusion. We think in those circumstances, given the history, we're still waiting for her to tell us what is so special about this complaint that she had to investigate it.
But the fact that you don't know or may not know what the special circumstances which the law allows her to do this based on, not knowing those special circumstances doesn't necessarily mean that she doesn't have.
Well, it must.
Or there were no special circumstances.
Well, it must mean that she doesn't have if she couldn't articulate them, because we've asked her to articulate what those special circumstances are. And we've articulated exactly what I've just said to you. There are many other authorities, our enforcement authorities, the prosecuting authorities, Judge Nugent, sitting as a commissioner of inquiry, who's looked at the very same set of facts. What is so special about this complaint that it required her attention? We do not have an answer. And absent an answer, we can only conclude that there is none.
Now, is it part, or is it going to be part of your strategy to use the fact that, one, a high court lambasted her for the way she carried her investigation into the Estina dairy farm saga, but also that she was also criticized for basically not knowing, the limits of her powers with regard to the ABSA and the South African Reserve Bank matter? Is that part of your strategy to say this is the kind of person that we're talking about here?
We do make, in our papers, we do make those kind of statements. We do say that have regard to prior court decisions and pronunciations on the manner in which her office has conducted itself, and we say we equally aggrieved in the same way that those parties were aggrieved by the failure to have regard to fact and law in arriving at a decision which is now the basis of a report. Yes, we do.
Okay. You have filed, right?
Yes, we have.
Now, what is your understanding of what happens in the interim?
In the interim, we want to contend that the situation is no different from a judgment issued by a court which is subject to an appeal. Under the Superior Court Act, you get an automatic suspension of that particular judgment, meaning that it has no effect until a higher court has regard to it. In this particular case, we're saying she's a functionary, and being a functionary, constitutional as it might be, once a court process is commenced, then deference must be given to the outcome of that court process, meaning that the report, including its remedial action, must be suspended. We understand she contends otherwise, but that's our position.
But it's also what you are contending.
Of course it is.
Now, okay, until you get a court date, what happens between now and that time when you actually go to court?
We say if you apply our common law principles in this particular situation, a decision of a functionary which is subject to a review process ought to be suspended. If there's a dispute about whether it is or not, we will approach a court, or any other affected party can approach a court to say, hang on, suspend the effect of this decision pending the outcome of a court process. I have no doubt in my mind that any court applying itself to such an application would come to the conclusion that it is a functionary, and a functionary is normally a human being, and they may have erred, and until a court pronounces otherwise, let's not implement the effects, and in this case the remedial action recommended, until a court pronounces upon it, because that's why we have courts, so that they can tell us whether the decision, the report, the remedial action is in fact correct or not.
Now, we all know what's involved here. President Cyril Ramaphosa is expected to announce his cabinet, most probably tomorrow. Right? Now, in terms of what the African National Congress has been doing over the past few days, and it's all out there, the work of the Integrity Committee, several people who have come before it. What do you think is the effect on your client of where things are? Not what you're hoping for, but where things are right now. Here's, let me put it clearer. If the ANC says anyone who is implicated in some wrongdoing, whether by a court of law or by the public protector, and there's a ruling, that person should not be eligible. Yeah. Let's say that's what the ANC decides, for argument's sake. right? Let's just say that's what the ANC decides. Now, surely, if that then is the case, I don't think you expect your client to be appointed to cabinet, do you?
Well, the question you put into me is political, but I'll answer it from a legal perspective, and it's simply this. If a court's order is suspended by a further court process, such as an appeal, surely a ruling, a report, and remedial action by a functionary, such as the public protector, must be subjected to the same type of result. But most importantly, and I mean, to delve into a realm that I don't live in, a world I don't live in, but let's not forget that Minister Gordhan has not been subjected to an integrity commission process. He has not been, as a result of this particular complaint. And let's also not forget that this complaint has been alive in the minds of many people since 2016. It died a natural death and should have remained there when the NPA withdrew the charges. And all of a sudden it woke up a day before the president is inaugurated. So, I mean, you connect all the dots as you normally do as journalists. All we're saying is that this process that we have embarked upon, which is a review court application of the report of the public protector, must of necessity suspend its effect. And put differently, for instance, just to give you an example, she says the president must subject the minister to a disciplinary action. But as you and I sit now, I keep on calling him minister, but he isn't. In fact, he's Mr. Pravin Gordhan, because cabinet is yet to be announced. What disciplinary action can possibly be implemented at this point in time? None. You know, and we say it's one of the reasons that she's gotten it wrong.
Okay. Here's what opposition politicians think of your case.
We're in support of the Constitution. A Chapter 9 institution has released the report. In defense of the Constitution, we're defending the Chapter 9 institution. And anyone who's offended by this report must take it on review. You can't call for the removal of a public protector because you are not happy with the findings of the public protector's office. So take it on review. There are many judges who have made wrong judgments, including Nicholson on Zuma, which led to firing of Mbeki. That decision was overturned by the Supreme Court of Appeal. Why didn't people say, since the Supreme Court of Appeal has overturned and had harsh words to say about Nicholson, Nicholson must be fired? They couldn't say so because for every judgment of the lower court, there is a recourse. For every remedial action by the public protector, there is a recourse. So let people take it on review.
Is he wrong?
Well, he's wrong in some respects and correct in others. He is right in saying that the Constitutional Court has pronounced on the matter. A remedial action by the public protector must be implemented unless taken on review. And that's exactly what we've done. We've taken her report and the remedial action she's recommended on review. So that's ticked. But the implication of a review application as we've brought is quite different from the suggestion that the public protector must be removed from office. That's not a case we're making out, and that's not our place to make that case.
Oh, but yeah. You're right.
So on that score, I think it's a different debate, and whether there are grounds for her removal or not is not our case. Our case is simply these are the facts, and this is the law, and we think you have it wrong, and a court should review and set aside your report.
And from where you sit, the fact that you did today file your application means that her, or should mean that her report is put in abeyance, and it means that her remedial action has to be suspended.
That's what we contend. But think of it this way, Vuyo. If the remedial action is to be implemented, firstly, it can be because Mr. Pravin Gordhan is not a minister and can be disciplined by the president, as she suggested should be the case. But secondly, and most importantly, the President can't be instructed through a report by the Public Protector on how to constitute his cabinet, which is the only effect of the remedial action that then remains. And we contend, therefore, that her remedial action, as recommended in her, as set out in her report, is suspended by the review process that we've now put into motion, where a court will now determine is her interpretation of the law correct, and is her reading of the facts correct. And we've set out in great detail why we think she's got it wrong.
And you disagree with the notion that it is actually, it stays, her report stays pending a successful review on your part?
Think of it this way. If all functionaries, and let's put this matter aside, if all public functionaries exercising public power out there, if every decision that they took exercising that public power or performing that public duty was allowed to remain pending a review, then all of us would be subjected to that conduct, notwithstanding that it is potentially reviewable when the court ultimately hears the matter. We may be forced in our hands, not necessarily us, but other parties, may be forced to approach a court on an urgent basis and say, hang on, stay the effect of this remedial action until a court properly ventilates whether the report is lawful, constitutional, or not. And in the ordinary course, those orders are not even matters which require people to bring court applications, but the functionary would say, I'm happy to hold back my decision and its implementation pending the outcome of a court process. And of course, that's deferring to the judiciary, which oversees all of this conduct in the end, including the Public Protector's report.
Okay, that's what we're going to leave with. Thanks very much for your time
Thank
this evening. Pravin Gordhan's legal representative, Tebogo Malachi.